the first person.
Hey, why are you not paying attention?
Hey guys, I have an idea. So since the company have its legal entity, that means we can take that advantage to commit crime, right?
I think it's not that simple, but it kind of feel right. So we need to discuss the idea of corporate personality, which is the idea that a company is its own person, separate from its shareholders and directors.
Exactly, like in Essential Malaysian Company Law in Malaysia, written by Chai Wai Ming. This separation lets a company own property, makes contracts, and also be liable on its own. And that's where the corporate will comes in, protecting the shareholders from their personal liability. Yeah, I read up about Mr. Robert B. Thompson's study piercing the corporate veil. It shows that this protection is crucial for investors, but also a heavily debated issue in corporate law, as the courts can pierce the veil and in any cases of frauds. Speaking of which, in Malaysia's case, Ong Leong Chow, a federal court looked at veil piercing, even referencing the English case press.
So shall we look into some landmark cases like Solomon and Solomon?
Let's go!
In the early days of corporate law, Mr. Solomon was quite the boot business bigwig, but running it solo. Not Mr. Salomon. He created Salomon & Co. Limited, transferring his entire business to this new company. Salomon was the boss, with 20,001 shares to prove it. His wife and 5 kids held the rest, just 6 shares among them. He even loaned his company £10,000, secured by its assets. But trouble hit. Creditors demanded Salomon pay his company's debts. The courts initially agreed with them, but when it reached the House of Lords, they had a different opinion.
No. Salomon & Co. Limited is its own legal person. Just because Mr. Salomon controls it doesn't mean he is the company.
And that's how Mr. Solomon became a legend in company law. And thanks to him, we have corporate personality. And it's even codified in Section 20, Sub 1 of the Companies Act 2016. True, but there are exceptions. Court can still use pierce the veil for misuse, similar to UK as in N. Ejim's notes. In the Ong Leong Chow case, a federal court looked at these exceptions, even referencing to press and petrodol for guidance.
So the press sets a really strict criteria, allowing the veil piercing only for misuse or evasion of obligation.
So, like as you can see here, Malaysia's approach to corporate liability is evolving, affirming the corporate personality with limits. But why not let's just dive deeper to the concept of the fundamentals. Let's go guys, let's head to the tutorial class.
Oh, it's time! Let's go!
Okay, good afternoon everyone. Today we will be examining a cornerstone of company law, corporate personality. So upon incorporation, a company becomes its own legal entity separate from its members or subsidiaries with rights and obligations. As you can see here, corporate personality equals to independent legal entity. As Turai Singham Joshi and Balan explaining the concise principles of Malaysian company law, corporate personality allows a company to enter contracts, own property and incur debts independently. Most importantly, corporate personality creates a corporate veil, a protective boundary shielding shareholders from personal liabilities from the company's debt. This veil was established in Salomon and Solomon case, where the House of Lords confirmed that creditors could only pursue the company's assets, not Mr. Salomon's personal assets due to the company's separate legal entities. In Malaysia, Section 20 of the Companies Act 2016 codifies corporate personalities, affirming that the company is its own legal person and that the corporate will protect shareholders unless there are valid grounds to fit. Solomon and Solomon set this protection in motion, but it also sparked many debates and development afterwards.
Mr. Solomon! Any comments on your victory? It seems that the corporate veil remains intact.
Indeed, the court ruled that Solomon & Co. Limited is its own person. My assets are now safe, thanks to corporate veil.
What
Press veil piercing was inconsistent. Courts lacked a standard approach. Professor Mueller noted the case law was filled with incautious dicta and inadequate reasoning. Judges often ruled without clear explanations, leaving the doctrine vague.
So each judge decided on a case-by-case basis?
Exactly. Rulings relied on terms like facade and alter ego without clear definitions. In Adam and Cape Industries, for instance, facade was used without clarity, adding to the confusion.
It must have been frustrating that each judge had a different view of a facade.
Exactly. These inconsistencies shifted veil pressing from law to judicial discretion, threatening corporate personality. The lack of clear guidelines led to unpredictable, sometimes unjust outcomes.
Without a solid framework, veil piercing became the last resort, only applied when absolutely necessary.
Precisely. This is why Press and Petrodo was pivotal, setting clearer limits on veil piercing.
Thank you for your clarification. It's fascinating to see how this doctrine has evolved into a more structured form today.
As you can see, the Press case involves the application of auxiliary relief in a divorce proceedings. Mrs. Press sought the transfer of several properties legally owned by the Petrodo Group, a company fully owned and controlled by Mr. Press, as part of the divorce settlement. Mr. Press denied ownership of the properties. The court was thus required to determine whether it could order the transfer of company-owned properties to Mrs. Press.
In this case, Mr. Press can transfer the properties on 3 grounds, which are the piercing of the corporate veil, of to give effect relief, or disregarding the corporate veil pursuant to a wide range of jurisdiction conferred by Section 24 of the 1973 Act, or lastly, the company holds the property on trust for Mr. Press. Allow me to explain the doctrine of piercing of the corporate veil. The phrase piercing to the corporate veil means to disregard the separate personality of the company. This allows the court to pierce the corporate veil if the corporate personality is being abused for the purpose of some relevant wantons.
There are 2 principles on which the court can rely to identify what amounts to relevant wrongdoing, namely the concealment and evasion principle. The concealment principle applies when a company is set up to hide the identity of the real actors, allowing the court to look beyond the corporate veil to reveal concealed flags. On the other hand, the evasion principle applies when a company is formed to evade an existing legal obligation, and only under this principle can the veil be pierced. Piercing the veil remains a last resort, used only if conventional remedies are inadequate.
I don't agree with the doctrine of piercing the corporate veil based on the evasion principle alone.
Okay, my clever students. So now, as you all have know what is the Press case about, I want you all to tell me what is the impact and how does it affected the doctrine of corporate veil.
Honestly, I don't know, doctor.
No, that's not the answer I'm looking for. But it's okay. The answer you are searching for is that.
The door?
No, the library. From now on, I'm going to give you all 1 minute to search for the answer. Any later than that, I will deduct your marks from your continuous assessment.
What?
Time is ticking, Yvonne. What have you found?
Oh, I found here. It says that the Press case clarified the distinction between piercing and lifting the corporate veil. Previously, in the Jasker Mellon, the court noted that the term piercing the corporate veil was often misunderstood. In Atlas Maritime and Avalon Maritime, the court defined piercing as threatening a company rights and ability as those of its shareholders, while lifting allowed the court to look into shareholding for legal purposes. However, later cases like Yukon Lines and VTB Capitals overlooked this distinction.
Yes, very good, Yvonne. In Press, Lord Sumption's judgment illustrated the actual distinction between piercing and lifting. When the veil is lifted, the court is not disregarding the separated legal personality of the company, but merely discovering
the concealed truth. Conversely, when a veil is pierced, the court disregards the separate legal personality to impose liability on the relevant parties. I assume you have found the answer, right?
Yeah, I found the answer you're looking for, Doctor.
Can you tell me more about it?
So, based on my research, even after Solomon, courts continue to use vague language rather than standardized terminology to describe the defendant's misconduct. In John's case, for example, the veil was pierced because the company was merely the defendant's device and assumed a mask before his face to frustrate a specific performance claim. Similarly, in the Wall Steiner case, the court described the companies as the puppets of Dr. Walter Steiner, which danced to his bidding as he pulled the string. Although these terms aim to describe abuses of corporate personality, they fail to clarify the law, leading to confusion and uncertainty. Unfortunately, the press case addressed this by allowing the courts to apply the concealment principle when a company acts as a facade to hide the truth and the evasion principle when it serves a sham to evade legal liabilities.
Yes. An example I can give is in the case of penny feathers, where instead of relying on ambiguous labels such as sham or facade, the court adopted the concealment and evasion principle.
Doctor, here's my answer. So, one of the impacts of the press case is that it helped to narrow the grounds that make it available to pierce the veil of operations. So in Ben Hashim, the court outlined principles for piercing the corporate veil, which is first, ownership and control alone do not justify piercing the veil. Second, justice alone is insufficient to pierce the veil. And third, piercing requires both control of the company and impropriety in using to avoid or conceal liability. And lastly, the veil will only be pierced when necessary. So the press resolved these issues by standardizing the law and narrowing the grounds for piercing. Firstly, it affirmed Ben Hashim and rejected the interest of justice as a ground for piercing. Secondly, it permits piercing only through evasion principle. For instance, when a company is incorporated to evade existing legal liability.
Oh, I understand now.
Bravo! You guys are very, very smart. But you guys can be smarter if you guys find one more answer to my question.
There is more?
Yes. So now keep finding and never give up. By the way, where's Yvonne?
I'm here.
So Yvonne, what is the last answer to my question?
Last answer. I thought I gave you answer already, Doctor. We found it.
I know guys are the smartest and the greatest. Come, now tell me what you guys have.
The last but not any less important impact is that press made piercing a remedy of last resort. But actually, scholars have opined that existing authorities do not support such a proposition. Instead, piercing has always been invoked when necessary and not as a last resort. It is therefore noteworthy to discuss the two cases referred to by Lord Sumption, namely the Court of Appeal in VTB Capital and the High Court decision in Ben Hashim.
In VTB, the Court of Appeal held that the piercing of corporate veil need not be a remedy of last resort. However, this was overruled by Lord Sumption, who opined that the position in Ben Hashim ought to be preferred. However, scholars have pointed out that Ben Hashim is not an authority to support the propositions that piercing is a remedy of last resort. The terminology used in Ben Hashim was necessity, an existing authority, that the test of necessity does not require that there are no practical means, remedies of resolving the issue at hand.
I agree with the both of them, Doctor.
So, I know press case has a lot of impacts, but I also heard a lot of criticism about it, right? So, I want you all to look into it.
Guys, let's split up and ask around. Cool?
Yeah.
Okay, see you. Bye.
Hi, excuse me. Do you mind?
Oh yes, what's the matter? I can't see me taking picture.
Sorry. So, we know that you are the top law student.
Okay, not really.
So, I'm just wondering, like, what do you think about press case?
This case, I'm honestly not quite happy with the case, you know. It contradicts and lacks of justification in treating veil piercing as a last resort remedy. These cases cited by the Supreme Court seem contradictory. For instance, while demonstrating veil piercing under the evasion principle, Lord Sumption used Guildford Motor Co. Limited and Horn and Johns and Lippmann as illustrations, but in both of these cases, other remedies were available.
Exactly. If you see in the Gilbert Mortal, Lord Samson noted that injunction against the company could be granted on the basis of tort. Similarly, in Jones, the specific performance order against the company could also be achieved based on the individual's control over the company. Although these cases demonstrate the distinction between concealment and evasion, they contradict the principle that veil piercing can only be done when no other remedies are available.
Thank you so much. So sorry for disturbing. Thank you.
Sorry to disturb, but let's know about press case.
Yeah, press, right? It's a quite famous UK case.
But I remember reading from somewhere that it was criticized as it lacks judicial consensus on whether to limit the veil piercing to evasion.
Yeah. Most judges actually accepted Lord Sumption's classification of concealment and evasion, but some were skeptical of restricting the doctrine of veil piercing to evasion cases. Both Lord Mans and Lord Clark pointed out the danger of foreclosing all future veil piercing situations to cases of evading pre-existing liabilities, disagreeing with such restriction.
Lady Hale also questioned whether all piercing cases can be simplified into concealment and evasion. Their concerns highlight the risk of binding courts' hands in rare or exceptional future circumstances. So, this lack of consensus introduced uncertainty. Should future veil piercing cases be limited strictly to evasion?
You know what I found? Apparently, Singapore's position offers a possible solution. So, in Raffles Town Club and Lim and Peter, the court pierced the corporate veil to prevent unconscionability when directors rely on the corporate entity for personal benefit. So, this aligns with Baroness Hill's suggestion that certain situations of unconscionable advantage warrant a veil piercing, even if they don't fit nearly into concealment or evasion. So, this means adopting unconscionability as a threshold might balance certainty with justice.
Nice! Thanks guys, really appreciate your help.
Let's go.
Hey, nice one. Don't go first. I want to ask you guys something. Do you still remember what was the last criticism which Doctor mentioned? Yes. The third and final criticism about press case is that it seems to be unnecessary to differentiate between piercing lifting and concealment evasion. Well, Lord Sumption's approach to resolve the piercing lifting dichotomy by introducing the evasion concealment principle raises questions. Firstly, as you can see, there is no practical differences between the effects of piercing and lifting the corporate veil. Secondly, as you can see here, practically when a person conceals facts using a company, they often simultaneously evade pre-existing obligations. Therefore, concealment and evasion frequently coexist.
An example can be seen in the case of Darby, where two undischarged bankruptcies incorporated a company, LIC, which bought and transferred a quarrying license to another company, WSQ, which is a public investors, later looked into the debentures in WSQ, which eventually went into liquidation. So the court disregarded the structure and claimed secret profit from the bankrupts, viewing LIC as merely an alias. So this could be seen as both concealment, which to reveal the true actors behind the LIC, and also evasion by using LIC to evade fiduciary duty.
Yeah, you're right. Similarly, in Guilford's case, although Lord Sumption classified the injunction against the company as evasion, Lord Neuberger argued it involved concealment. This conflict highlighted that judicial disagreement on distinguishing concealment from evasion. Further clarification from the Supreme Court on the distinction would be beneficial when a suitable case arises. Oh, I understand now. Yeah, thank you for helping me, guys. Doctor, Yvonne answered already.
Alright, perhaps you can share with me.
Seems like although press is commendable for its attempt to clarify the doctrine of veil piercing, its decision is followed by some criticisms. Firstly, its lack of justification in treating veil piercing as the last resort recently.
Secondly, it lacks judicial consensus on whether to limit veil piercing to evasion.
Thirdly, it seems to have unnecessary differentiation of piercing lifting and concealment evasion.
Well done, students. I'm impressed. Perhaps you guys can look into the Malaysian court, how it plays these principles.
Okay, Doctor.
Thank you, Doctor.
Okay, so good day everyone. Today I would like you guys to discuss 3 Malaysian cases that apply the principle established in press and patronal resources in the context of piercing of the corporate veil.
Good day everyone, today I will be presenting on the case Lau Kam Loy and Vortex. In In this case, the plaintiffs filed a claim against defendants which concerned the transfer of share owned by the first defendants, Boltex, in Dragonbyte Holdings. The basis of the claim is Exhibit Plaintiff 1, a document signed by the plaintiffs and several other defendants but not Boltex. The Exhibit Plaintiff 1 states that the shares of Dragonbyte held by Boltex were to be transferred to the first plaintiff and his nominees. As a result, Boltex filed a counterclaim against the plaintiffs. Here, the Court of Appeal also determined that the corporate will may be set aside in the presence of special circumstances such as instances of common law fraud, equitable fraud, or when a company acts merely as a facade to hide the true facts. That's all from me.
Can we have the next group of the presentation, please?
Good day, everyone. Today, Husna and I will be presenting on the case Gurbachan Singh Bhagawan Singh and Velasamy Punasamy. In this case, there was a dispute over estate land purchase between former clients and their ex-solicitors. The respondents claimed that they agreed to buy the land and make partial deposits. The solicitors initially helped delay the auction by filing caveats. The first appellant bid on the land, won, and later claimed it as his own property. He then suggested the respondent buy shares or plots from him under a new agreement. Soon after, the first appellant transferred ownership to a company he formed with others.
The High Court ruled in favor of the appellants. However, the Court of Appeal overturned this decision. Key issues in the appeal included whether the solicitor-appellant relationship and duties were limited to retainer agreement, whether a fiduciary could recover expenses made for a benefit owed to those to whom the fiduciary had duties, and whether the court could lift the corporate veil to address the potential misuse of a company for fraud, even if fraud wasn't initially argued. So the doctrine was expanded to allow the court to lift or pierce the corporate veil in cases of fraud. If fraud is committed through a company, the court can disregard the company's separate legal entity. So this makes the individual personally liable for their actions, even if they are just a member of the company. It also prevents individuals from using a company as a shield to evade responsibility for fraud and ensures accountability despite the protections normally provided by corporate structure. That's all from us. Thank you.
Very insightful. Great job, group number 2. Shall we have our last group before we end our class today?
Hello everyone, today Simone and I will be focusing on the case of Ong Leong Chiu and Keller. In this case, a dispute arose between the Malawati Mall project and Bina Puri Holdings Berhad as the main contractor. Bina Puri subcontracted to Perfect Selection Sdn Bhd, which then subcontracted to PS Bina Sdn Bhd. PS Bina further subcontracted to Keller Sdn Bhd, the plaintiff in the original suit. Tony Ong, the appellant, was a director of shareholder in both Perfect Selection 50% and PS Bina 40%. Later, Keller sued for unpaid sum of 7,462,720 ringgit and 19 cents related to empty bore work EBW performed. The High Court found Ong misrepresented that Bina Puri would cover EBW costs to induce Keller into a contract with PS Bina. Keller performed EBW and initially received payments from PS Bina, which were later reversed, leading to significant losses. As such, the High Court concluded Ong committed fraud, with PS Bina as a sham company to block Keller claims. The court lifted the corporate veil, establishing joint and several liabilities against Ong, PS Bina, and Perfect Selection, which was later upheld by the Court of Appeal.
The Federal Court referred to press decision where Lord Sumption set out the concealment and evasion principles. According to the concealment principle, it allows courts to look beyond a company to reveal true actors if the corporate structure conceals identities without piercing the veil. Whereas the evasion principle permits veil piercing if a company is used to avoid a legal obligation of its controller, particularly where a legal right exists against the controller. In Ong Leong Chiu case, the Federal Court found Keller had a legal right against Ong due to his fraudulent misrepresentation. The court applied the evasion principle to pierce the veil, holding Ong, PS Bina, and Perfect Selection liable. The court also emphasized that fraudulent alone justifies disregarding corporate personalities, allowing liability based solely on fraudulent conduct. That's all from us. Thank you.
Yes, you guys are certainly right. I think you guys did a very good job. And shall we call it a day?